discovery in terms of the Rule 26F conference, Rule 16 conference, or rather, meetings have schedule order. We talked about relevance, meaning what's the scope of discovery. What do they mean when they say the information that you're requesting has to be relevant to the proportional needs of the case? So you can't randomly ask for things that are not relevant to the legal issues in dispute. We talked about proportionality and privacy, specifically some of the limits on discovery. You can't automatically get access to people's health and mental examinations, for example, or evaluation of consulting witnesses or the visual impressions of an attorney. We talked about initially how there are mandatory and required disclosures that have to be shared with each side, meaning disclosure of information. It's just automatic, that as soon as the case gets to discovery, know that you have a legal responsibility to do those things. We also discussed the various discovery tools. We talked about interrogatories. These are just tools you can use to gather information from the other side. We talked about depositions. We talked about request for additions, another discovery tool. Physical and mental examination, and then we talked about request for admission. So again, these are just different tools you can use to get information from the other side if you need to build your case. And then lastly, sorry for making you a little nauseous there, we talked about work product, why that's protected and under what circumstances. Today we're concluding our discussion of consulting experts. As you might remember, there's two types of experts. There are consulting experts and then expert witnesses, so those that are testifying in trial. Consulting experts are just serving as counsel to help you with your legal strategy, but their information is not discoverable, as we'll highlight today, unless two circumstances are in play, two exceptions, but as a general rule, consulting experts' information is not discoverable. And then we'll end class, which is sanctions. And I think I've already emailed this PowerPoint to you all. Yes. So sanctions, and just kind of what options the courts have to compel people to respond to discovery actions that they should be taking or information they should be given. All right. So before we actually start things today, a couple of housekeeping measures. So tomorrow we're doing just an exam review session. So I do have practice multiple choice questions that I'll be running through in class for you to answer. But the bulk of the exam review, I want you to, so there's no reading assignments, I want you to look at your outlines, those of you that have them. Look at your notes, and if you see any gaps or questions that you have, I want you to email me the questions, and that will make up the exam review. If I see a lot of the same questions on the same topic, I'll spend a little bit more time, but I will address each question that is emailed to me. So I need you to email me the questions by tonight. If you can email them by, say, 10 p.m., give me that plenty of time. And then I already have pretty much, I'm trying to hit every topic, but I'll make sure that, I wasn't going to talk about this, but I need to address this because this is an area of confusion. So again, I'll send you a reminder email me your questions by 10 p.m., and I'm happy to address them. Additionally, on Thursday, I forgot what they call it, some kind of weird name. Monday. Yeah, I think that's dumb. So I'm not taking roll on Thursday. Since I have the classroom space, I'll be in here sitting down for class. If you have a question, you can come in and ask me. I'll just be in here on my laptop, but I'm not taking roll. But again, I'll be here again just because you have that time in your schedule that is open, there's no conflict, in case you have any last minute questions. So but I want to emphasize that I'm not taking roll on Thursday, and I'll just be in here as considered in office hours time, so you can come and ask any questions you may have. And see if there's anything else. Oh, the Masters. Crazy. Who saw the Masters? Anybody? At least you saw the replay, like when everything blew up. So here's how pathetic I am. So I don't play golf. My significant other plays golf. I went out with them because I'm like, it can't be that hard. Just come play golf. And I was like, yeah, whatever. I'll go to the driving range. So I rented I just checked out the in charge, like a girl driver, and I put the ball down. I went to swing because I thought I was gonna look all cool swinging. And I swung, and I'm looking for the ball. The ball's still right there. And so I tried to do it again. And I'm like, why is it this hard to hit the ball? And my husband kept saying, you can't take your eye off the ball, you can't take your eye off the ball. But I feel like, it just feels, it's harder than it looks. And I thought it can't be that hard to hit a little ball in a hole, right? And so that experience let me know I don't want to play golf because people that play golf like the challenge of trying to improve their score. I don't. I get frustrated. It makes me feel like I'm not good, like I'm not athletic, like I'm not smart enough to figure it out. It frustrates me like math. So I don't like it. So I don't play. But I will ride hard just to keep my husband company on a nice day. And so I say that to say approximately maybe 9 years ago, I knew what the sport of golf was, but I was dating this gentleman who said, hey, I was living in Atlanta, you want to go to Augusta? I got some tickets for my job to go to the Masters. I didn't even know where I was going. And it's like now I'm looking back, and I'm like, how was that the Masters? I didn't understand what the Masters were because I wasn't a golf person, but I went, and it was beautiful, and Tiger was playing, and there was literally like he had a following from hole to hole. But now, of course, I couldn't get tickets if my life depended on it. I just wish then I knew the significance of what it meant to be at the Masters. But it was great seeing, I'm not really a fan of Tiger for various reasons, but it was nice seeing someone, I like when people don't give up, and for you to try 11 years to win another major and not give up, I admire those stories of resilience. And I think of it in terms of law school, how, regardless of how you feel you're doing in law school, how important it is not to give up. They had a guy here speaking a little while ago who I mentioned him earlier, I think his name is Byron something, maybe Smith, but like he's literally doing a big-time entertainment lawyer, making a lot of money doing what he loves. We had a graduation speaker, the lady who's CEO, or not CEO, she's something high up, maybe she's CEO of Starbucks, her name is, I just had it on my tongue, but she did like really bad in law school, and she's like killing the game, grade-wise, and another lady who's a general counsel for Warner Brothers in Hollywood, who's a U of L graduate, and she said in her graduation speech, I graduated, she said in the bottom quartile of my class, and look at me now, and everybody laughed. So I say that to say, yes, grades are used, I'm just reminding you, as a standard that a lot of the law firms use for that first job. But when you're out in the field, your merit, your dedication, your tiger, the tiger in you is what determines how well you do and how far you go. But just remember there's no limits, and I hear success stories all the time, so just remember that. I know eventually they're going to lose to a point where they're going to follow Harvard's model and a lot of other models where there's just pass-fail, because it's really silly I think. If you pass the bar, I mean, why do we care what your grades are? You're obviously competent to be an attorney. All right. Class. So I'm going to go by the honor code and just ask everyone, if you haven't been called on, can you just raise your hand? I had to go honor code in there because your classmates were calling you. So we've got got 1, 2, and 3, 4, and 5, 6, 7. You guys are rocking it the whole semester. Out of you 7, do either of you want to volunteer for today? Because you probably figured you were on anyway. Anybody want to volunteer? No. All right, so let me give you numbers. Raise your hands again. So you're 1, 2. You haven't been going on either? Wow. 1, 2, 3, 4, 5, 6, 7, 8. You're 9 and you're 10. All right. So 1 through 10. Okay, so there's someone coming in late because of a car issue. Well, actually 2 people. So they won't be here in time. Is that them? Oh, you know it was someone else. It was Tabitha. Tabitha, she moved. And I saw you. I'm glad you made it. Un momento.
Yeah, there's people walking the hall if you want to come pick a number. That's terrible. Like less than a random number. Oh, there's a red. I just took a picture. Like, really, so years. The
only reason I'm not saying is I want to seem like I'm playing favorites because I know who to, the numbers, so she doesn't know what's going on. So I need you to pick any random 3 numbers and just put a circle around it.
Oh, God. I love this.
So these are people I haven't been called on this semester, so these are the ones we're going to carry over. So sorry. They know who I am. Thanks. All right, so all right, let's listen. So who are attorneys? What are your last names? Go ahead. How can you spell it? P-A-C-H-C-H-U-S-Y. Attorney number 5.
Hoffman, H-O-F-F-M-A-N.
Sorry, she did it. I didn't do it. And then 8.
Oh, that's recount.
What are you with 8? 1 or 2 other over here? 9, 10. So yeah, you're 8 then. I was going this way. So you've been 8, 9, 10. Lawson. And where you don't want to volunteer? Okay, good colleague here. All right, so let's finish our discussion of consulting experts. So just a further reminder, consulting experts are governed by Rule 26B-4D. And again, it just says a party may not, by interrogatory or deposition, discover facts known or opinions held by an expert who has been retained or specifically employed by another party in anticipation of litigation. So normally, basically, you just can't get access to information prepared by consulting experts. However, you can get the information if one of 2 things are present. So again, the only exception to getting information from a consulting expert is 1, if the expert is an examining healthcare professional under Rule 35B. We talked about that in the last class. So one of the exceptions to getting information from a consulting expert is if the expert is an examining healthcare professional under Rule 35B. Remember, Rule 35 addresses mental and physical examinations. It talks about when a court may require a party to provide a mental examination and discusses how you would get a copy of such. The second exception to consulting experts is if the party seeking the information can show there are exceptional circumstances, i.e. why they can't contain the material elsewhere. So the party seeking the motion will show, Your Honor, these are exceptional circumstances. This is the only way we can get this information. We can't get it through any other means. Okay? So that's the second option. Okay, so let's talk about the Thompson v. Haskell case. What was the plaintiff's underlying claim about? Either Attorney Bacchus, Hoffman, or Lawson. What was the plaintiff's underlying claim about? Yes, thank you.
She was subjected to sexual harassment by a supervisor who was employed by the Haskell company, so nobody's known her. There was repeated advances, and she was fired when she did not acquiesce to those advances.
Excellent. Okay, so we know the plaintiff was terminated from her position with defendant Haskell Company, as he stated. Therefore, her mental and emotional state are at issue because she's claiming mental distress, right, as a result of the sexual harassment or harassment. Attorney, where are the other 2 attorneys? What is the discovery issue in this case? What did the defendant want, and what was the argument? Yes. Excellent. Okay, so what happened is the plaintiff had examined, plaintiff was examined by Dr. Lucas 10 days, right? 10 days after she was terminated, and her, again, mental and emotional state are at issue. So this is highly probative with regard to the above-quoted allegation. Meaning, what was her mental state of mind? Was she, really shaken up? Was she depressed? Was she, having anxiety because of the alleged sexual harassment she was receiving? So they considered to be essential to the case. In Thompson, as you might recall, a psychologist had shortly after the plaintiff's dismissal examined the plaintiff, who was now again claiming this. This mental distress. So, Attorney Bacchus, right? What was the information the defendant sought? Why was it relevant that the defendant sought?
So, the defendant wanted the information to support their case.
Okay. Why is it relevant? Meaning, remember the relevancy? Like, why is it relevant to the case?
Show her mental state.
And is it privileged?
Yes, but it falls under the exception.
Okay. So I'm going to come back to you with the exception, but very good. Okay, so we know that it's relevant because, again, the plaintiff's emotional state is at issue in this case. If the psychologist was acting as a therapist, and if the state in question recognized a therapeutic privilege, then the patient's communication would be initially privileged. But the privilege would have been waived by a suit when you put the patient's mental state at issue. So all that's to say, there is like a therapist privilege that says what you discuss with your therapist is privileged information. But when a lawsuit, the basis of the lawsuit is your mental state of mind, your emotional state, then that gives you access to that information. So that's why it's not privileged. What was the plaintiff's argument? What type of order did the plaintiff file? She's like, hey, I don't want you having access to this information. How did she stop that? Yes.
I think the 26.4 rule.
Perfect.
That Dr. Lucas was employed only for trial craft, and the records were shielded from discovery because of this.
May I ask you a curiosity question? You're obviously prepared and doing very well. Why don't you just volunteer? I never understand.
Well, it helped me study better, actually, because I was always afraid of being on call. Kind of forced me to.
It is unfortunate because you could have pulled up the brakes. That's why I'm saying, like, the times earlier in the semester when I said any volunteers, why didn't you be like, let me just get this over with so I can, like, coast, you know, roll the dice. So you know you're going to get an A on the exam, right? That's how it always works. The people in the last class, they always get A's, so don't mess that up, please. All right, so we know the plaintiff is true. The plaintiff files for a motion for protective order. She contends based on Rule 26b-4, the consulting experts rule, that in particular the plaintiff says, look, plaintiff represents Dr. Lucas and was retained by her prior counsel to perform, again, a diagnostic review and personality profile, and then after seeing the plaintiff on that one occasion, Dr. Lucas prepared a report for her prior counsel. The plaintiff says, look, I want to shield these documents from discovery because, again, she's feeling like that was a consulting expert and that information should not be discoverable. So assuming that Dr. Lucas' report is covered under Rule 26b-4, it would nevertheless be discoverable under the circumstances presented in this case because they put her emotional state at issue. Again, the plaintiff alleges that as a result of the sexual harassment by the co-defendant, in this case, Zona, a supervisor in the employment of the defendant, she was, quote, reduced to severely depressed emotional state, and her employment was terminated when she did not acquiesce to the advances of Zola. So the court, in considering all of the facts in this case, said, you know, there's no other way for the defendant to get information regarding the plaintiff's emotional state 10 days after termination. The court said for this reason, this is really, you know, highly probative information, and it is discoverable, notwithstanding Rule 26b-4. Okay. Moreover, the court said, given the nature of the reported issue, apparently no other comparable report was prepared during the weeks immediately following the plaintiff's discharge, so there's no other means in which to evaluate or assess what the plaintiff's mental state was after that termination. Thus, the defendant cannot obtain the information contained in Dr. Lucas's report by any other means. So these are these exceptional circumstances that we see in the exceptions to the rule. And so the court felt like under these facts, it appears there are indeed exceptional circumstances favoring the disclosure of Dr. Lucas's report, and the defendant cannot obtain, again, comparable information by any other means. So the court allows the defendant to get this information. I really like this case because it does a great job of showing us kind of how challenges to discovery information happen in a court setting, meaning the other side, one party is asking for information that you don't feel you want to give up or should have to give up, and you know how you file a motion, you want to, you can either file a motion to compel discovery, they have to give it to me, or you can file a motion for a protective order and say, no, they're asking me for this, and we don't think we should have to give this information over. And then, again, how the court evaluates that. And in this case, it falls under that exceptional circumstances rule. So we're going to see a quite different framework when we cover the next case, which is the Chiquita Banana case. Most of you, I would think, feel it's pretty fair if your emotional state is at the heart of the lawsuit, that the other side should have information to that report. Does anyone say no, they shouldn't? Yes.
I say that that's a very slippery slope because they can try and use an underlying condition that you have against you, even if the claim you're bringing is in fact a valid claim. So, for example, in this case, let's say for argument's sake, just this woman had an underlying condition like if they have access to that information, they can try and use that underlying condition against her to claim that she's either making it up or that it wasn't that she's making it out to be.
So here's my question. Great point. If you were her attorney and the judge said yes, you have to give over the report of this information, what would you do? What would you try to do in terms of, you know, the report has to be given? What would you try to do? What would your gut tell you?
Is there a way to like limit what comes out of the report to make sure that they can't use that underlying condition against, they only use the effect that happened from the termination?
Yeah, so you would ask the judge to redact certain parts of the report that are not relevant to this case and that are privileged. Her emotional state 10 days following is relevant, but as far as her being diagnosed with bipolarism, you would petition the judge to redact that from the case. So when we cover the Chiquita Banana case, you'll see that they only got certain aspects of the report, consulting report, and not all of it. So does that make you feel a little better? Yes. Okay. All right. So I love this case, and the reason I love this case is I literally eat banana every day, and I just think they're amazing. So when I grew up in the summers, my grandmother had I know it sounds corny, but she had like all these, like, it was like a garden of Eden to me. So there were like ladyfinger banana trees, there were grapes growing like in the fences on the vines, grapevines, and orange trees, grapefruit trees. So I just this kind of reminds me of nostalgia of my grandmother. But I just love bananas, and I remember being a little kid and trying to make them fall because I wasn't tall enough to get to them. Has anyone seen what those ladyfinger bananas look like? They're like this big. Yeah, the little they call them ladyfingers. But I just think it's the perfect fruit, but I'm biased. So I love this case. I hate the stuff gets spoiled, but love the case. So. You know, I'm actually really gonna miss this class. I've said this before, and I don't mean it to be bad, but yeah, people are like, that section, you know, you guys didn't have like a real, not a bad reputation.
They're haters.
What?
They're just haters.
They were haters. This is like, I still love this class. Like, it's just fun. I mean, Dimitri helps out quite a bit. But, you know, I appreciate that personality. But sometimes like you get a class where they're just like so focused on having to learn everything, they can't even, they're like, they never laugh, they're no fun, and they're just like dry. It's like work. It's like you're at a funeral every day. But you all have really, honestly, I've really enjoyed this class, and I really sincerely hope that you all do really well, because it will really make me happy. But yes, I'm gonna miss you guys. Surely. All right, who can tell me the facts of the Chiquita case? Thank you.
So this was a maritime accident where the shipper is suing the carrier for cargo loss and damage. There was a malfunction of the vessel's loading cranes, and it caused the last boxes of bananas to be loaded onto the ship. And there were 43,000 boxes left on the wharf, and the bananas that were delivered were in bad condition. And the plaintiff sent out a maritime surveyor, and as a result, the defendant is seeking the maritime surveyor's deposition and files.
Excellent. All right, so we've got quite a situation going on here. We know the defendant, international vessels loading cranes and side ports allegedly malfunctioned, good, delaying and damaging this perishable cargo of bananas. The discovery issue, as she just highlighted, the shipper Chiquita plaintiff has a maritime surveyor meet the vessel at the port of destination. The surveyor prepared a report, and the defendant, the carrier, was trying to get the report and was trying to basically depose the surveyor. He wanted to know what was contained in the report, and so on. So, what type of expert is this surveyor considered to be? Testifying or consulting expert?
For the plaintiff argues he's a consulting expert.
Okay, because he was not going to trial, right? Okay, so what was Chiquita's argument as to why this information was not discoverable, meaning this surveyor report? What was Chiquita's argument? You kind of just said it.
Yeah, basically, he's not really any other purpose but just figuring out what happened and surveying the accidents and this.
Absolutely. So he's like, look, I had no intentions of bringing this person to trial. They're not a testifying expert, so they don't fall under Rule 26b-4b. Which I forgot to mention, Rule 26b-4b was changed. There were amendments made to the rules December 2010. So now it's 26b-4d as in dairy. So it changed. But in your case it says 26B4B, so in place of D is right. So it's now D like the area. They made amendments in 2010. Anyway, so normally you can't ask information, as we know, by consulting experts. You can only get the information again if it falls into one of those two circumstances like we just saw in the Thompson case. So Chiquita's argument is like, no way, we're not giving up that information. We don't have to, not a testifying expert. The defendant says, no, Your Honor, don't listen to them, and says what? This is why we should get this information. What's the defendant's argument? Go ahead, Nate.
Because he's the only one that surveyed the ship and the accident scene. That warrants an exceptional circumstance.
Absolutely. So the defendant says, Your Honor, these are exceptional circumstances, and we need access. There's no other way now that the cargo has been damaged. There's no other way for us to get access to the state of the cargo when it arrived there. And so imagine if you have a lawsuit against someone about a product that was not properly delivered, and before you can, send someone out there to make sure everything was shipped as planned, it gets damaged. You don't know if the order was complete, so they really need access to the surveyor report. And the defendant also said, even if we can't depose the expert, fine, we will accept that if we have to, but we should be able to at least see his file. International Reefer maintains that, again, even if they're foreclosed from disposing, Mr. Weiner, it should be given access to their file at the very least. Is the distinction between fact and opinion testimony important when you're trying to make a Rule 26B4D determination? What does the court say? They say, is it even relevant? Do we care about making a distinction between fact and opinion? Yes, Did you?
No, it's more towards if it was conducted in that the distinction lies, or if the information was put in the normal course of business, where the idea of
Excellent. Yes, yes, and yes. So the court says, no, it's irrelevant. Okay, we don't care. They say that when you take a look at the rule, it specifically says you generally cannot obtain access to known facts or opinions held by, again, a consulting expert unless you satisfy one of the two exceptions. If you look at the first paragraph on page 507 of your text, the court says that the relevant distinction is not between fact and opinion testimony, but between those witnesses whose information was obtained, as he said, in the normal course of business, and those who were hired to make an evaluation in connection with expected litigation. So according to the court, is the surveyor a witness or consulting expert? What does the court say? What do they say Mr. Weiner is? Consulting.
He's a consulting expert.
Okay, in more detail? So, a witness or consulting expert? Or rather, expert, sorry, I want to say consulting.
It's a non-testifying expert, but they classify that. They call it the latter category of 26B4D.
Yes, great job, great job. So the court says, in one sense, we're acknowledging Mr. Weiner's not a witness, he is an expert, we just define what type. The reason I say he's an expert, he's a maritime engineer, and he's specifically engaged or hired by Chiquita to examine the vessel in connection with the cargo loss claim. He's clearly an expert, he brought his technical background to bear in observing the condition of the gear, and the court said he does not forfeit his status, and now said he's a witness, merely because he made a personal examination of the vessel, and therefore learned facts, rather than simply offering an opinion based on the observations of others. And so, in terms of the holding, the court's holding and reasoning, they said the International Reefer, nevertheless, contends that discovery should be permitted under exceptional circumstances, clause of the rule, and the court says, this argument would have merit if International Reefer had been precluded from sending their own expert to the scene by forces beyond its control, and they said, but that's not the case. They said the plaintiff didn't bar the defendant from examining the vessel after it docked. They could have done their due diligence and sent their own surveyor out that. So they said, the court said, under these circumstances, International Reefer's failure to engage its own marine surveyor in a, quote, timely manner should not be rewarded by permitting discovery of Chiquita's expert. To do so, they said, would permit the exceptional circumstances to, in a sense, swallow or undermine the whole purpose and spirit of having Rule 26B4. One of my attorneys